All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for Protecting Home and Legacy, Understanding and Drafting Ladybird Deeds in Florida. Before I introduce our speaker, I want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy of the recording and materials from Zoom within about 24 hours. We will also be posting it on YouTube, and you will notice that on YouTube, I've been adding the CLE code. I will also add a link to the materials as well. And feel free to subscribe to our YouTube channel. That way you get notified as soon as we publish these. And speaking of YouTube, this particular webinar is going to be an amazing tool for pro bono recruitment. So if you're out there and you're a volunteer and you want to connect with legal aids, watch this webinar, learn about Ladybird Deeds, and we're going to have a template that I'm going to be dropping into the chat soon in the materials so you can access it. And I will let my colleague Brooke speak a little bit more about the pro bono opportunities in a minute. So as I said, CLE code is going to be shared towards the end. It will be included in the email that goes out from Zoom, and it will also be included in the YouTube description. This one was approved by the Florida Bar for one general CLE credit and one real estate certification credit. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility, feel free to reach out to me directly. The training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I will be dropping the link for the website into the chat. It will also be included in the materials. It will be included in the email from Zoom, and it will be included in the YouTube description. So take a look at the work groups that we have. It's a great opportunity for the private attorneys to learn more about public interest work and connect with legal aid attorneys. So we have a lot of members who are both private attorneys and public interest. So membership is $55 a year. We have a lot of CLEs, and for law students, it's actually free. So if you're a law student that would like to connect with public interest law attorneys, feel free to look at our website. And final piece of housekeeping announcements, questions and answers. So if you have any questions during the presentation, feel free to drop these in the chat. We also have the Q&A, but I think today we're going to try to focus in the chat. If we see that the question is related to the slide, I'll pop up and interrupt and say like, hey, we have a pending question. If for whatever reason we miss a question, we'll try to address them at the end if we miss anything. So with all of that said, I think that's my last housekeeping announcement. I'm going to, before I pass it over to our speaker, I'm actually going to pass it over to my colleague, Brooke Eleazar Mack, a staff attorney with Florida Legal Services. Brooke reached out with the idea for this webinar, so I want to pass the mic over to Brooke. Brooke, the floor is yours.
Thank you, Jorge. You all, we are so lucky to have Lipscomb-Smith this afternoon to present on Ladybird Deeds. Latonya is the Heirs Property Project Manager and the Managing Attorney for Three Rivers Legal Services. She's been with Three Rivers Legal Services since March 2019 at the inception of the Heirs Property Program with the firm. And the main components of the program today are probate litigation, estate planning, and education community outreach. And the goal of this program is to preserve safe and secure homes for at-risk homeowners by helping them to get clear ownership of their homes and create a plan for transfer of homeownership in the future. And like Jorge alluded to, after this presentation, you are going to be prepared to provide others with Ladybird Deeds, and which you probably already know impacts a client's just family for generations. Florida Legal Services is a statewide organization, and if after this webinar you'd like to volunteer as a pro bono attorney with Florida Legal Services, please contact our pro bono director, Stephanie.storke at stephanie.storke at floridalegal.org, and I think Jorge is going to put that in the chat. And we will work to pair you with a client in need and provide support services. And so without further ado, Latonya Lipscomb-Smith.
Thank you, Brooke. Thank you, Jorge. I am very honored to be presenting to you all today on Ladybird Deeds. Like Brooke had alluded to, with our Heirs Property Project here at Three Rivers Legal Services, this is a cornerstone of our practice. We have been doing Ladybird Deeds in our estate planning world since our program started in 2019. So happy to share this legal tool with everyone today. So our agenda today, we are going to discuss what is a Ladybird Deed, a little history on the topic, the legal foundations, formal requirements, the advantages of it, the disadvantages of it, because there are some, and the overall assessment. As also alluded to, please feel free to enter any questions that you have as we go along. So, what is a ladybird deed? What we're talking about today is um, uh, the proper term for it is an enhanced life estate, but please keep in mind that it is a quit claim deed. Um, you are drafting a deed, and so there is a sense of responsibility that I think that we should do in terms of doing a deed research. When we are doing any type of deed drafting. This is a tool for passing property to beneficiaries upon the death of upon the excuse me, a tool for passing property to beneficiaries upon the death that avoids probate. I like to say in our firm that we want to work ourselves out of a job in terms of probate litigation because this is a very good cost-effective tool that we can provide to our clients where their heirs or beneficiaries do not have to go through probate. This is a type of deed for permitting the current owner to use the property during their life, and then only if the owner still owns that piece of property when they pass away does it pass automatically to the beneficiary. So all that a beneficiary or vested remainder has to do is provide a death certificate and get that recorded. And so the transfer of that property happens automatically, which is quite beautiful. So, what is in a name? You will hear in this world interchangeably enhanced life estate, ladybird deed. When it comes to drafting, please do not, in my opinion, use ladybird deed. You want to use the proper legal term of enhanced life estate or reserving an enhanced life estate. But the myth behind the ladybird deed is that this was a part of the estate planning tool for President Lyndon Johnson that when he was doing his estate planning, his attorney had drafted it in such a way that uh, President Johnson still retained ownership of the property, but only upon his death would his real estate transfer automatically to his wife. Come to find out in doing research, this is not true. The Ladybird deeds did not exist until 1982, so 10 years after the Johnsons' death. And so, in reality, we have credit should be given to Jerome Slokoff, who is a Florida attorney who used the fictional names of the Johnsons when he was explaining the concept of this type of deed. But either way, I can say that it has stuck. And so it's here to stay. So we will continue to call it Ladybird Deeds. The legal foundation for ladybird deeds. It is not explicitly permitted or forbidden in statute. This can become problematic because we have found recently, actually, that a lot of mortgage companies or title insurance companies outside of the state of Florida who might not be familiar with ladybird deeds, they may give you pushback in terms of the deeds. So, what we have been advising clients to do is folks who are interested in getting a mortgage or refinancing their mortgage, we would encourage them to go ahead and do that prior to doing the ladybird deed so that it could avoid all of that issues. And then once they have done that, to come back to us and we'll be happy to do the ladybird deed. But just keep in mind that when your clients might need to refinance or get a mortgage on a property that may become an issue at some point in time. We have found that communicating with them, with these companies, sending them letters, that has helped to iron out that issue. Ladybird Deeds has gained legitimacy from an important Supreme Court case from 1917 called Oglesby versus Lee. And it is in that particular case that holds that the reservation powers of a life tenant is invalid. That's the only really sense of historical statute that we have regarding this. Ladybird deeds, it's only recognized in 5 states here, in 5 states in the United States: Florida, Texas, Vermont, West Virginia, Michigan. I will say that um, the not the opposite, but a companion to Ladybird deeds are TODs, and those are transfer on death deeds. So a lot of states that might not recognize um, Ladybird deeds, uh, they do produce TODs. TODs are similar in the sense that it's um, it's 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 a mechanism that after the death of the landowner, that property automatically transfers, but there are distinguishing features. I do know that Texas is one state that has both Ladybird deeds and TODs. So just know that there's a distinguishing features between the two. And then also, if you practice in other states, you may be aware that even though we may have Ladybird deeds or call it the same, there are distinguishing factors when you go between those 5 states. I love this chart because, uh, as mentioned, a ladybird deed is an enhanced life estate, but just know that at the cornerstone of the enhanced life estate is that it is a life estate. So you cannot ignore that feature. And this chart is a great reference for you to have. In the beginning, I would print it off and just have it as a good reference to know the difference with regular life estate. The uh, life tenant, the grantor, they do not retain full control or ownership. They cannot deed the property, do anything of ownership value to the property without the consent of the remainderman. I will say that in our practice, we come across a lot of instances where clients they believe that their parents had a life estate, and it wasn't until we actually read the language of the deed that we had to give them very hard news that um, that it was not a ladybird deed and that it was a traditional life estate. That happens often, which is why it's so important to make sure that you have the proper language in your um, enhanced life estate that gives it the special enhanced power for ladybird deed. Can you mortgage the property? Yes, you can with an enhanced life estate. You are still considered the owner. You can sell it. You have the authority to remove the remainderman. Removing the remainderman is a popular example of why clients will come back to us and change their mind. They might get mad at their children or whoever that they had deeded it to. Things have changed, but that is a good power that clients love, and they do utilize it. They like to change their remainder men. You do not lose your homestead tax exemption on the property. So you can still maintain those exemptions. I will say, putting on my heirs property hat and tax exemptions, there are other property exemptions that you can claim outside of homestead. Please be sure to utilize as many that is applicable to your clients. Every county has a list of the various types of property exemptions that they can apply for. We do have more than just the homestead. There's also the homestead exemption for creditors. The life tenant does not lose that protection either, which is great. The property is protected against those creditors. Judgments against vested remainderment. This is a concern that a lot of clients will have when they come to us because they know that their children might be in debt, and they want to keep the family in the home. They want them to have it. So when you have an enhanced life estate, um, it the vested remainderment, the creditors against them, does not attach to that home. Does the remainderment's vested interest in the property before you die? No. with an enhanced life estate. In a traditional life estate, it does. Um, and the last one I point out, property expenses. With a traditional life estate, it is the responsibility for the remainderman. It is not. With an enhanced life estate, it is the responsibility of the life tenant because you are still considered the owner. The three advantages that I'd say for the Ladybird deed is that it allows the current owner to have complete ownership and autonomy while they are alive. Um, I have found that with a life estate, folks have buyer's remorse. You know, the owner thinks that they will not change their mind, that they trust whomever that they are listing as the vested remainderman, and folks will have buyer's remorse. But the beauty of the Ladybird deed is that the owner, the life tenant, is still considered the full owner, and so you can operate as such. It avoids the need for probate. Um, our clientele, we are a legal aid. And so our clients, their family members, they do not have the money to be able to pay for probate litigation. And so this is a great tool to utilize so that the property can transfer automatically. Let me also say, take a pause and talk about trusts. This is a mechanism, Ladybird deeds, of avoiding trust. Trust is what we say is kind of the five-letter dirty word because we are fighting against media and society in terms of trust. Trust is the sexy word that clients hear about, and so when they come to us for services, they everyone says that they want to trust. Even our low-income clients, I want to trust, and a big part of our job is the re-education of people and our clients in terms of trust. And most of them, they after we re-educate, they are on board, especially when we talk about the Ladybird deed. But please know, since this audience is a lot with pro bono attorneys, um, if you run into a client that is talking about trust, don't turn them away to say, oh, I don't do trust. There's nothing I can do for them. Take the time to speak with them and educate them on this cornerstone of estate planning. And oftentimes, that is all that they need. They just want to know that their loved ones are receiving their property in the best fashion possible, which the Ladybird Deeds offers a cost effective way to do that. I added to this slide that a Ladybird deed does not require the creation of a will, but we still do it. Our practice, we call it estate planning. Within our estate planning, we do wills, deeds, and advance directives. The reason why we like to do a will in conjunction with the Ladybird deed is that what if, for whatever reason, it fails? The will offers a nice safety net for the property to go based on the grantor's wishes, just in case that deed fails for whatever reason. We have had horror stories where if clients did not record their deeds before they passed away, yes, you can record the deed after the death of the grantor, but if we found that there was something incorrect with the execution of the deed, that there was only it wasn't notarized, that there wasn't enough witnesses. It is nice to have the safety net of having a will so that ultimately the wishes of the grantor are honored. So I highly recommend doing wills in conjunction with Ladybird deeds as well. So Medicaid is one of the benefits of doing a Ladybird deed. We do not do Medicaid planning here in our firms, and I am sure that on this call that there are Medicaid planners, Medicaid attorneys that do elder law that's well versed. But just a couple of highlights that I wanted to bring your attention to for Medicaid is that the 5-year look back rule. Um, that does not apply when you're considering a Ladybird deed. And the reason why is because the owner, the person applying for these benefits, they still maintain um, ownership of the home. And so it's not considered that the home is not considered as a transfer. So that's one of the major benefits. And then also regarding ACA, the home is still protected as well. So the formal requirements for the deed, Jorge dropped in the chat for you all a sample of the deed, so you all have that to look for, to look at your leisure. But I didn't add it to the slide because I knew that you all were going to have your copy of it. But this is it. You want to make sure that you have the name of the grantor, that you have the explicit language of the enhanced life estate. We're going to dig into that a little bit. You want to name your remainder beneficiary. You want to provide a formal legal description of the property. Let me just pause and say, do not just name the address of the grantor or the parcel ID. I will say that parcel IDs, I've seen folks that use them. I see folks that don't. Just know that the parcel ID does change. It can change in the counties, and that's why you want to name the legal description. And then you would have a homestead provision if it is applicable. Regarding, we'll talk about the homestead a little later when it comes to disadvantages. So the requirement for the grantor, obviously it needs to be the current owner of the property. Know that the person in question who is splitting their interest in the property between themselves for the duration of their life and to the beneficiary after their death. The deed, it must be witnessed by 2 individuals and a notary. I will say in the past year, a change to the witnesses is that there needs to be an address for the witness listed for on the deed as well. So not just their name and signature. You want to make sure that the address, that every witness has an address as well. Requirements for the remainder beneficiary. This is a person or a group who inherit ownership of the property after the death of the grantor or the life tenant. They have no ownership interest in the property until the death of the life tenant, and then they inherit the full ownership. As discussed before, you definitely don't want to list just a postal address, and you want to have the description of the land as recorded with the county land records. I will pause. Let me go to the next screen as I do a big pause. Drafting Ladybird deeds. Title search, title search, title search. As mentioned, this deed, it is not a warranty deed. It is a quitclaim deed. And because of that, it's not going to be formally insured by insurance. But I feel that if attorneys are doing the drafting, that it is a good practice for you to not take on face value that your client says that they own the property. You want to verify to your own comfort that that person actually owns it. We have found countless times that clients have come to us. I want to do a will. I own this piece of property. Once we do our own personal title search, we find that there's a probate that needs to be done, that the property is heirs property. We have found that they actually don't own it. Folks have contract for deeds. Clients come to us thinking that contract for deeds means that that is a actual deed and that their parent owned the land. A contract for deed does not convey ownership. It is just an agreement. I think it's a glorified rent to own. But after when you're looking at a title search, if you have a contract for deed, after that, you want to make sure that there is a traditional deed that conveys the property. So I do know that there are a tendency for folks to want to do clinics, to want to do these one-stop shop for estate planning. I'm not a fan. I think that if you're going to do a Ladybird D clinic or an estate planning clinic, that a lot of homework needs to be done before the actual signing of it. You want to make sure that you have done a proper title search for that property before you actually sign. I do know of some firms that have the resources and that they can farm out to title companies to do a search for it. We do not. So we have been very blessed to have very good training. So all of our staff, attorneys, and paralegals, they have a good foundation and training on how to do title searches. And so I highly recommend that you do that before you start drafting anything at all. And then when we come across a very hairy situation, we will farm it out and pay for a proper title search. Um, Knowing that anyone can do a deed, we have found countless times that family members love to deed each other stuff. You get a one fifth, you get a one fifth, you get a one fifth. And then when you have an attorney come and look at the history of the deeds, it's a nightmare. So oftentimes, getting a proper title search, getting a survey done is necessary before you actually do the Ladybird deed. So that was my little soapbox with my heirs property hat that I had to share with you all. Title search. So,
So, Tanya,
uh,
I was going to
yes,
interrupt because we do have a few questions that are relevant to these topics. The
sure.
first one came in, it's a little bit more relevant to the prior slide.
Uh-huh.
And the question came in from Courtney, which is always the best question asker. I have to always give her props.
It
Thank you,
came in from
Courtney.
who?
So,
Courtney?
so
Welcome.
Courtney
Mhm.
asked, would you recommend a Ladybird deed for multiple properties when one property is the homestead and the other property is land, or is it better to just have a will that includes all the property to be transferred?
So I do all the above. I will do um, the ladybird deeds, but in the will, very good question. What I say in the will, something to this effect, is at the execution of this will, I have also recorded ladybird deeds that reflect X, Y, and Z. Then I'll say in another paragraph or in another sentence, if that fails for any reason, I then repeat what the Ladybird deed says. So it may be redundant, but it's a good lawyer redundancy, in my opinion. It's just, protection after protection. So, yes, I do both the labor deed and name it in the will.
Right. The other question is to confirm for a person to revoke a Ladybird deed, they just need to redeed themselves an FSA quit claim deed to themselves and record it, correct?
Correct. hmm hmm Um, and some folks, they already know who they want to rename as a vested remainderman, so you can just do that. You don't necessarily have to just deed it to yourself. You can do it all in one. I will share that in a recent situation that we had in house with a divestment deed, where we had a client who um, wanted to refinance their mortgage. We had done their Ladybird deed, and she was getting a lot of pushback from the mortgage company. And they said, for us to do a divestment deed, which essentially we redeeded it back to herself. She refinanced, and then we did another subsequent Ladybird deed. Mhm.
We do have two more questions that just came in, so I'm going to go ahead and ask them. The first
Sure.
question is, what's the lawyer's potential liability in preparing a Ladybird deed?
Uh, well, I I'm glad for our malpractice. And when you do pro bono work, you're under the protection of malpractice of the firm that you're doing. I know FLS will have that as well. There's always that possibility, which is why title search, title search, title search. If you feel uncomfortable with doing title search, it is worth getting doing a training, taking a class, getting a mentor. Um, but it's not difficult, but it is a good skill set to learn. And you're able to combat a lot of mishaps by doing that.
The next question, I have to do a quick plug for Aaron Irving. He actually led a webinar about a year ago on pro bono
Hmm.
opportunities. It's a great way, if you're a volunteer, it's
Yes.
a great way to learn about legal aid and how to volunteer. Aaron covered, insurance and some of the benefits of volunteering with legal aid and how you can fall under that umbrella. So Aaron actually asked the question, the next question, which is, can
Uh-huh.
you do a ladybird deed for non-homestead property?
Absolutely. Absolutely, you can. And we'll talk about the in a little bit the hairiness of homestead with ladybird deeds. But yes, you can do it on any real property.
Right. So no further questions for now, but I'll keep a lookout
Thank
in the chat. So,
you. Thank you so much. Um, so these are the major five elements that we discussed previously, drawing your attention to step number 4. Traditional life estate language and language regarding grantor's unrestricted power to convey, sell, grant, mortgage. The every bit of language after the and is what gives us the special enhanced life estate. And it is heartbreaking to see deeds that have the title enhanced life estate or ladybird deed. And when you actually read the body of the language of the deed, it is missing. It actually reads as a life estate and not as enhanced life estate. So drafting the language with that special, the deed with that special language is paramount. So the first paragraph for good and valuable consideration paid by the grantee beneficiary, that is the language that comes after, if you're looking at the sample deed that was provided to you, after that witness paragraph. Usually it's the nominal amount of money that you will have when you're doing a quit claim deed. But this bottom language here, uh, with the grantor reserves a life estate for him or herself during their lifetime. You want to also make sure that we have come across situations where it almost sounds like this, but what is missing is the ability for the grantor to be able to reconvey it back to him or herself. Um, and it's those situations that's very heartbreaking that we have found that really reads as a life estate and not as an enhanced life estate. So this language is important and it is definitely included in your sample deed that you have um, been provided. Homestead. So, what to say about homestead? We know that the grantors, they do not lose their homestead exemption status when you do an enhanced life estate. When you are doing a ladybird deed for a homestead, you want to identify that that property is the tenant's homestead. That's just a good practice tip to have in the deed. Um, and as I mentioned, you don't want to miss out on the other property tax exemptions. I want to quickly go on to this slide regarding homestead limitations. We live in a society where folks like to marry and divorce quite often. And so, because a lot of our clients are older men and women, they are coming into marriages later in life. They have adult children. And so, when we do outreach events, um, we come across a lot of folks that say, oh, well, he has a house, I have a house. And I want to leave my home to my adult children so it can be given to my grandchildren later on. One question that I'd love to ask is, what is the homestead, your all's homestead between you and your spouse? And then break the news to them that they cannot give away the homestead if they are currently married or if they have minor children. That is really a game changer to a lot of folks. Um, it becomes a big stickler because there's no way around this rule. You can have it where um, if the other spouse who doesn't currently own it, they can sign on to the Ladybird deed, acknowledging their homestead interest and agreeing to the conveyance. They can do it then. But I will say that what if they change their mind later and they want to litigate it in court? It is a constitutional protection. I haven't seen it yet, and so having the spouse add it to the deed and them signing it, I think is a good uh, way for someone to acknowledge that other spouse signed away their interest, their constitutional interest, but they could still fight it. Who knows? But if you are in a marriage and you want to leave your home to a child and you are married, just know that it is an uphill battle and that on its face, it is against Florida Statute 732-401. But the workaround is that if your spouse does sign on to it, the hairiest situation that we have had was a married couple who they claimed to not have a homestead. And what was crazy about it is they were living in two separate homes and that they just traveled one to the other during the entire course of their marriage. The wife had a home in Georgia. She had a Georgia driver's license. She had a Georgia home. The husband had a Florida home. He had a Florida license, and they really weren't living together. That was some creative lawyering. They wanted to deed their property in all different ways. We definitely had them sign um, the deeds and so forth, and we haven't heard from them, but that was the most hairy, is that they claim to not really have a marital home or ever have a marital home, um, but they were still married. So we'll see what comes of that. Multiple beneficiaries. So um, avoiding heirs property is the name of the game. You will probably rarely have people come to you where they only want to leave their home to one person. It is common practice that folks will say, "I have 5 children, I have my home, and I want to leave it to all 5 kids." Um, I put this type of scenario in the same scenario of trust in terms of re-educating clients about showing their love and expressing their love to their loved ones in the same fashion and creating heirs property. When you leave a piece of property to more than one person, you are creating heirs property, period. However, um, we do utilize joint tenants with right of survivorship. That helps to discontinue the continuing fractionation of the property with each generational line. So instead, you have a parent who has 5 children. They are insistent and wanted to leave it all five with joint tenants with right of survivorship. At the death of each one, the ownership um, continues to dwindle into the last surviving person of that line. Um, I can talk all day about multiple beneficiaries. It's not it's just not a good plan. It's not a good plan because at the end of the day, um, you are giving your home, you are giving a financial responsibility to your loved ones, and we talk to our clients about the ability of leaving the financial ability of the maintenance and upkeep of the home to all of the children. Um, some folks get it, some folks do not. And so we encounter quite often the devastation of family relationships, of a parent leaving their home to multiple kids, and then the kids having a falling out because not everyone steps up to the plate and do the responsible thing. It usually only falls to the one or two out of the group that does the right thing. However, when it comes to wanting to sell the home, do anything with the home, you still need to involve all of the co-owners of the property. So when you are drafting and consulting with people, you really, really want to stress with them the reality of what it means to own to have multiple owners on the property. Not everyone is going to do the right thing. Not everyone is financially able to be a homeowner. So I think it is incumbent on us to to give our clients the medicine, to tell them the hard truths, and try to convince them to show their love to their children in other ways than just giving all 5 kids one house. Little Heirs property soapbox. Thank you.
Look, Tanya, we did have a few questions related to multiple beneficiaries, so I figured timing
Sure.
wise, it would be a good time to ask them. I know there were other questions first, but I figured let's ask these questions now because they were related to this topic.
hmm
The first question was, what options do you guide a client or do you provide a client who insists on deeding a home to all 4 children? How do you fix that?
I paint them horror stories. I will I'll do financials with clients. I will go through what's the annual cost and maintenance of the home, the property taxes. I will get in their business in terms of um, does your any children, are they current homeowners? Do you know that you are providing an extra financial burden on them? What if not all of the children will do their part and spread it equally? I think that parents naturally have a kumbaya um, mentality of that these are my children. I have raised them well. They're going to do the right thing. They're going to do well by each other. But the reality is, when those bills come in the mail, not everybody steps to the plate. And it's a joy when clients get it, but you will have some sticklers. And so my personal thing is that they have to do joint tenants with Thrive survivorship. I do tell them that I really do not do tenants in common because that is going against the heart of our program of Heirs property, and that thing is never going to quit. So I lecture, preach, talk to them as much as possible. I get most of them, but there are some that I can't convince. And I do leave it with joint tenants with right of survivorship at the end of the day.
And now I'm reading one of the questions that came in first, that I think I can connect with this topic. The question is, will a ladybird deed cause any problems to the grantee if they are on public benefits? And I'm thinking in this scenario with four children, maybe one of them is on SSI or some means tested benefits, and suddenly they have access to a non-homestead property or maybe the proceeds of the sale. Maybe that is part of the conversation. So, I guess kind of going back to the question, any problems that they could cause to the grantees?
It while the grantor is alive, no. But once the grantor passes away and they own the property, oh yes, absolutely. It becomes their asset. So that's another part of not quite Medicaid planning, but those um, social benefits that you should take into consideration. Um, but yes, once the grantor passes away.
And here are two more questions. The next one is, if there are multiple beneficiaries, do you recommend titling the remainderment as joint tenants with rights of survivorship as opposed to tenancy in common?
1,000%. Joint tenants with right of survivorship all the way, every single time, because you are it is heirs property, but at least with joint tenants with right of survivorship, you are stopping it. The ownership will dwindle with the deaths of the remainderment until it's one person remaining.
All right, and the next question is, since Ladybird, oh sorry, how can personal property be impacted by a Ladybird deed, especially when concerning multiple beneficiaries?
Personal property,
Yeah, I'm
maybe real
not sure if I
property.
understood the question.
Say it one more time. Let me see if I can.
Yeah, the way it reads is, how can personal property be impacted by a Ladybird deed? So I'm not sure if it meant, oh, personal versus real property. That's
Um, Ladybird deeds, it does not affect personal property at all. This is definitely in the world of real property only. So land, vacant land, homes. Um, it does not have any effect on personal property at all.
those were the pending questions that I think we had. So hopefully I'll go back
Okay.
just in case we missed any, but back to you.
Okay. Thank you so much. So along the lines of those questions, this also brings us to our current slide of the disadvantages of the descendants. Um, Keep in mind that when you are doing the Ladybird deeds, dependent on who are the vested remainder that is listed, most folks will do it to the next generational line. Uh, Children are the most common, but know that it does not stop with them, that it is advised that uh, every generation should be doing the Ladybird deeds. Um, I I like to say that in the beginning of our program, I used to say often that we like to work ourselves out of a job in terms of estate planning, but I have amended it recently in the sense of we want to work ourselves out of a job for having to probate. That's the benefit of doing this type of estate planning with Ladybird deeds. But we are not working ourselves out of a job completely because it warms my heart when we have the children of our original client come to us and they want their own estate planning done. That is a victory to us because that tells us that the family got it, they were educated. Our client didn't just hold on to this information themselves. They poured it into their children, and that their children are then coming to us for their estate planning. So, at each generational line, if you're dealing with a particular family, you want to make sure that they continue to come to you for Ladybird deeds. Disadvantages of insurance and mortgages. We have been talking about this throughout the program so far. Um, you you could run the risk of mortgage companies or insurance companies not understanding what a ladybird deed is. If that is the case, we have written on behalf of our clients, we have spoken to them, but oftentimes these representatives, their response to us would be, well, point us to the statute that gives you the authority for the ladybird deed. We don't got a statute here in Florida. We do not. It would be fantastic if it's codified, but we currently do not. It's just a practice that we've been doing for decades now. So just know that that is a possibility. I'll also share that because the majority of our clients, excuse me, are older, they don't have a mortgage on the property. But when they do, as I mentioned earlier, we have done divestment deeds where we basically redid our work. We did a deed where the grantor received the property back. They got the mortgage that they needed, and then we did the Ladybird deed afterwards. Um, that's just what we're encountering now with it, and it's unavoidable. So just know that that is a possibility of something that you could encounter. So coming to the end, the overall assessment of Ladybird Deeds is that it is a wonderful, uh, cost-effective way of avoiding probate. Um, Take care and do your title search. Sorry for sounding like a broken record. Before you even get started, you want to make sure that you can trace back the ownership of that property, that it properly does that it properly does belong to the grantor that you are drafting for. You do not want to skip that step at all. Um, and because we have so many wonderful heirs property projects across the state of Florida, um, I think most people are trained on how to do that. So, as a pro bono attorney, you can ask the firm that you are doing your case for mentorship or tutelage on that if you feel that you need it. But please, please do not skip that step. Um, the Ladybird deeds, it is a great way of avoiding trusts. Um, Folks will come to you saying that they need trust. Don't let the conversation stop there. Um, do a little bit deeper dive with them and teach them about ladybird deeds, and know that you can accomplish what they want to do in a trust 9 times out of 10 by completing um, a ladybird deed. And that is it for the
We do
presentation.
have a few, we have a few more questions. So there's
Yes.
one that I accidentally skipped over and I want to make sure we address it. And it's going back to the title search. And the question is,
Hmm.
can attorneys indicate in the that the document was prepared without the benefit of a title search?
Absolutely. It's to bring your attention to the sample deed that you all were provided. We absolutely put that language in there. It is,
I will drop the link to the materials again. It includes a Word
and
version of the template, so I'll drop them here. If anybody has any issues accessing it, let me know. I believe
yes.
I turned it into not only do we have it in Word format, I think I also saved it as a Google document just in case for those folks like us that have Google, in case you need to
Hmm.
access it. So I dropped it in there and the chat as well.
So if folks are looking at the document underneath where I put the legal description, I have bolded underneath, no title evidence was requested or furnished in connection with the preparation of this instrument, and no opinion, express or implied, is intended by the above named scrivener as the marketability or condition of the title to or the boundaries of the property described therein. Plug and play that language. That is your CYA in terms of purporting that you actually didn't do an insured title search, but you still did your own title search.
Okay, so let me make sure. I was trying to download it as a Word document, but looking at the document itself, it seems like people were able to access it. And
Wonderful.
let's see, I kind of lost my other questions. Okay, so here's the next question. What is the disadvantage of the grantor just doing a quitclaim deed to the grantee, not filing it and putting it in a safe for safekeeping until the grantor passes away and then it can be filed?
Um, I don't, I, I don't, I don't know why. Yes, you can record a deed, an properly executed deed after the death of the grantor. That's true. But my question is why? Is it that you don't want to rock the boat with relationships? The beauty of the Ladybird deed is that the grantor can change their mind. So let's say that they record it and then they have a falling out with who they named as a vested remainderman. Go write another deed afterwards. You can do that. I don't like it. Record them. You
Yeah,
you
it's
might have a
risky.
fire. Right. You can have a fire. You can forget any old thing. Record them.
Okay, here's another question. Any special considerations when recording the death certificate after the grantor passes? Problems to look into if this is delayed by years?
That's a very good question. It depends upon each county. Here in Duval County, where I practice personally, we don't run into a lot of problems. They're educated often on this service, I think because we've done presentations for them, but simply you record it and you wait for it uh, um, to show up, and they will automatically change the ownership on the website. The other thing, just as a little side note, that's tangentially connected is the property appraiser and their websites. We love them. They do great work, but they are not attorneys. So mistakes are made, meaning who you see listed as the owner on the property appraiser's website, may not be it, which is why, going back to my soapbox of title searching, go and look through those deeds. Make sure that the owner that they're classifying as the owner on their website is the true owner. And if it is a mistake, call them, let them know. We have such a good relationship with ours now that they take our calls very easily. You may need to kick it up to a supervisor or so, but if you can bring it to their attention that they're incorrect and show them, they will change and update accordingly.
There's one question here that I accidentally skipped, and I want to make sure we cover it. Is there a benefit of choosing a life estate deed over a ladybird deed?
1000%. With a, the question was life estate versus enhanced life estate, correct?
Yeah.
1000%. Buyer's remorse. With a life estate deed, the person will have buyer's remorse. When you give it away in a traditional life estate, you cannot claw it back without the consent of the remainderman. Countless times we have seen it where families have had a falling out. A parent accidentally did a life estate. Why? Because it's a quick claim deed. Anybody can do it, and I did it, and now they want to change it. The kid ain't going to do it. They're not going to sign off on it. Um, an enhanced life estate is the way to go. It gives you the buying power. You can change your mind. You are still the owner. I just love it. Enhanced
Here's
all
a
the
really
way.
good question. Here's a question from Nick. Hey, Nick, any restriction on using a ladybird deed to convey property up for a nonprofit organization, like a church, as an example?
Hmm. Hmm. I would say no. Um, but I I would wonder about the church leadership. Um, on its face, no. But I would want to know. if they have any types of um, bylaws in place, um, dig into the financials and the leadership of the church first. Um, Very good question.
So
But
there's one
essentially,
question.
no.
Yeah,
Mhm.
sorry. Yeah, go ahead, finish.
I did. Thank you.
So there was one question that was, I guess, directed to me. Is this being recorded? And the answer is yes. Probably will be ready on YouTube in about a few hours. So I dropped the link to our YouTube channel. You can subscribe. That way you get notified as soon as it's published. But you will find probably hundreds of CLEs there. Some of them will be expired, but in the email that I'm sending out, I'm including a few recommended CLEs that we've recently had that involve pro bono work for all those that want to volunteer. Samantha Howell with Three Rivers, she mentioned some upcoming clinics and the ability to look at opportunities. So if you have a clinic, feel free to use this recording or to show it to pro bono volunteers so they can learn about this topic. And I know Latonya, you mentioned like this is not something that you want to do like immediately at the clinic and you want to do your homework. But this is something that if you're doing intake for somebody and you spot, this could be an opportunity to start. Okay, we have time. So let's look at the video, recruit the volunteers, and we may have a candidate for this. So let me kind of go through the chat. By the way, I did drop the CLE code. I want to read it out loud just in case. As I said, this was approved for one general CLE credit and one real estate certification credit. It's 251817 I will drop that code in the YouTube description as well, and it will be included in the email as well. So here is, let me see if there's any other question. So there's a follow-up question to the life estate one. So why have life estate deeds at all?
That's what got us started. We wouldn't have an enhanced life estate without the traditional life estate. So I don't use it. I don't think I've ever drafted a life estate, but I think that because deeds can be done by anyone and folks don't necessarily go to an attorney, when you get your PhD in Google Law and you just Google stuff, folks may have a tendency to choose a life estate versus the attorneys who know about the enhanced life estate. But a lot of practitioners do not do life estates.
And I know we're over time, so I guess we have one last question here that I may have
Mhm.
missed in the chat. What homestead language do you recommend?
Oh, regarding homestead, um, I just identify if you're looking at the deed, the very first paragraph where you're mentioning the grantor's name and the grantor. Uh, no, if you are deeding the homestead, when you're talking about the legal description, you can say there in the beginning that it is the homestead um, of the grantor. That's just added language that you can indicate. Um, I'll also add that while at bare minimum you want to have the legal description, you can put the address on there too. It's a good reference point. You just don't want to have only the mailing address. You definitely want to have the mailing address and the legal description, but you can indicate that it is the homestead of the grantor there.
All right. I know there may be some additional questions, but we are over time.
Mhm.
So what I'll ask, if anybody has any additional questions, feel free to email them to me and I'll connect you with Latanya. If we can share those answers. I'll try to come up with a way to maybe post any answers that come up afterwards in the materials and the resources. But with that said, Latanya, if you look at the chat, you will see a lot of thank yous and a lot of great presentation. And I fully agree. This was an amazing presentation. Thank you, Brooke, for connecting me
Yeah.
with Latanya and coming up with this amazing idea. As I said, feel free, any legal aid organization that wants to use this webinar to help recruit pro bono volunteers and to train them, feel free to use it. It should be available on YouTube in a few hours, and I'll email the link for everybody to use. So, with all that said, Thank you so much, Latanya. Amazing presentation. Thank
Thank
you,
you, everyone.
everybody that joined us, and everybody have a great rest of your Friday and enjoy your weekend.
Take care. Thank you.